Learn company law with me today. So I'm looking at acts done by either a general meeting, the board of directors, or a managing director. Will it also amount to acts done by the company? Let us look at what the Companies and Allied Matters Act has to say, or how the act views a situation like that. So in a situation where a managing director or the board of directors or the general meeting carries on an act, does anything whatsoever, it is treated as the act done by the company itself. Okay, so if they do anything, the law says it is the company that has done that thing. But if they do not have the authority to do that particular thing, and then they enter into a business relationship with anybody, and that particular person that they have entered or they are entering into that relationship with is aware that at the point of entering into that contractual relationship with those people, that those people do not have the authority of the company to do that particular thing. The act says that the company will not incur any form of civil liability from such an act because it is that person, by reason of his or her relationship with that company, is deemed to be aware of the absence of such authority to do those acts. But even though those people, the managing directors, the board of directors or the general meeting lacks authority to do those acts, where a company has now taken steps to make an undertaking that yes, this is what we are going to do in relation or in connection to those acts done. The mere fact that those acts were not covered by the memorandum of that company will not also take away liability from the company, which means that any liability that arises as a result of that undertaking by the company will also be borne by that company. Okay, now let us go a step further to look at where there are actually acts done by an agent of the company or an officer of the company. Let me remind you that previously in the past, if you go through my page, you're going to see I've talked about vicarious liability under the law of tort. So for somebody who is also in the line of business or you own a company, you also need to have an understanding of the rule or the principle of vicarious liability under our laws. Okay. Now for acts that are done by the agents of the company or an officer of the company. Let us look at a situation where uh, an agent has done something. Will it also be looked as an act done by the company? Now, the law says no, those are acts of that agent, except in a situation where the general meeting or the board of directors or the managing directors have presented that person during their meetings that yes, this person is our agent, this person is going to act on our behalf. Okay, because in reality, people actually see a lot of once somebody represents himself or does something on your behalf, then automatically the person becomes your agent. But now the karma is looking at taking steps further so that they can protect the interest and the image of that company. Now, karma is saying that look, for somebody to qualify as an agent that whose act will be borne by the company on its own through its either its managing directors, the board of directors, or the general meeting present that person as their own agent. Or maybe even after the person has done the act, they can come back and ratify that act or those acts done by that person on its behalf. Now, this brings us to the point where if you originally do not have the authority of that company to make such a decision or to do such an act, wherever you are executing that act or taking that decision, you must take that decision or do that act subject to ratification. And then you must also make that position known to the person that you are transacting with, that look, every decision that I am taking here will be subject to ratification by the company on whose behalf I am doing this act. Now, where you do not make that position known to the person that you are entering into that business transaction with, any liability that comes out of it, it means that it will be borne by you except the company ratifies. So the company has the right to rescind or to renege or to tell you that, look, we are not part of this because we did not actually authorize it. We don't want to also bear liability. Now, when you look further under this law of karma, you will now realize that, look, whatever it is, even as we are talking about acts of agents and officers of the company not being acts of the company, when it comes to those who are actually servants of that company or officers of that company in the executing their acts in the course of their normal employment, now the rule of vicarious liability will be called into play. Now, the company will not run away from liabilities that will arise from the acts of those who are servants or officers of the company who are doing their job or their business in the course of their employment. That is the position of our law. So to be able to understand when liability will arise and when it does, who will bear that liability, you must also know and ask questions to know the source of the person's authority. You also have to know the position of the company with respect to that person, as well as the transaction that the person is also entering into with you. This is Xavier Law Essence. This is where we give you premium legal tips to help you make informed decisions, live informed life, and discover the best version of yourself. We'll see you again.